Another area of intellectual property that can be very important to some companies are their copyrights. And there's certain basic fundamentals about copyrights that everyone should know. For the most part, copyrights are pretty easy to understand. The problem is most people have misinformation that they've been told over the years that they follow. So what does a copyright protect? It protects an original work of authorship fixed in a tangible medium. So it can't just be something that's, boom, it's there and it's gone. It has to be fixed in a medium. And then it protects it from various forms of copying. And those forms include reproducing the work, which most of us think of as copying. Creating a derivative work. So let's say I don't make a photocopy of what you've done, I kind of redraw it. A great place that this comes into play is in architectural copyrights. So you go and create a house plan that's very successful. People like it, it's got a really cool layout. What generally happens then is a bunch of your competitors and competitive contractors will get a hold of that plan. Either they'll walk onto the job at night and someone's left plans out, or they'll find a way to get it. And they'll reproduce the plan, making very minor changes, usually to the outside, so it doesn't look quite identical to yours. That's still producing a derivative work, and that can be very damaging to somebody who's created the original, because you can make a lot of money if you have the hot house plan. Or this can be anything. I'm just using house plan as an example. It can be if you've got a new book, you don't want somebody creating the sequel to your book. Another thing it prevents people from doing is distributing copies. So even if they didn't make the copies, they can't distribute them. That basically prevents people from avoiding liability by using somebody who's judgment proof to make the copies, and then they go out and sell them and make the money. Finally, it protects performance. If you choreograph something, if you write a play or whatnot, it's an infringement if you actually go out and perform the work for the public. And also display, if you're displaying the work for the public. Now there are some limitations. For example, something's sold, there's what they call the first sale doctrine, and that wipes it out. So if you buy a painting, you can display it. But there are limitations there, so you have to be careful and make sure you know what you're doing. So we went through all of those. These are important different rights and can really weigh heavily on how you enforce a copyright. One of the important things you need to remember with copyright is you should register your copyright early. And there's a couple reasons why, and we'll talk about those in a few minutes. So copyrights can protect art, they can protect music, they can protect books, software, architectural plans, virtually anything you put in a medium that people are going to want to copy, except functional features. So you can't, it's very difficult, for example, to copyright the design of a chair. That would fall under the purview of a design patent, or certain other designs. But architectural plans were specifically allowed, and the creation of a house from the plans is a derivative work that is protected. So they resolved that issue to make it clear that just because you live in a house, it's functional, it's still protected by copyright law. Okay, so let's talk about how a copyright is created. Number one, a copyright is created on creation of the work. If you are the author and you make something, it's copyrighted. Okay? It is not, however, registered, and that's the big difference. Okay? Registration is necessary to enforce rights. In most places, you actually have to have a registration. In the 10th Circuit, where we are, they require a registration from the Copyright Office prior to filing a lawsuit. There are some other jurisdictions, however, where if you can simply show that you have filed the registration, they will accept that. And the reason for that is the registration occurs on the day you file, even though it takes the Copyright Office many months often to process and get the registration back to you. The effective date is the date everything was received at the Copyright Office. So it's necessary to enforce rights. The second major reason is it provides for attorney's fees. If you have a registered mark or a registered copyright and someone infringes, you can get your attorney's fees in enforcing that registration. That will often tip the balance in litigation because the defendant thinks, well, I can outspend you if the attorney can say, yes, you can outspend my client, but you're going to pay my fees at the end of the case, suddenly they decide, I don't want to pay for my lawyer and their lawyer, and they usually settle and stop the infringement. The other important area where it helps is in what we call statutory damages. Normally, in a copyright, you get your damages. With statutory damages, you don't have to prove what those damages are. You let the judge just kind of take a guess at it. If the judge really doesn't like the other side, thinks that they've been engaged in bad conduct, he has a pretty wide latitude of what he can award or she can award to against the infringers. And so statutory damages can be a really nice thing to have. So registration is good in that way as well. Register early because it takes a long time. You can get an expedited registration, but it still takes a while and is expensive. It adds about $900 on the registration process or more. So just, if you've got a work that you think is important, file a registration on it. Most attorneys I know try and avoid actually registering the copyrights for their clients. They would rather teach their client how to do it for a couple reasons. Number one is it usually takes more time to get the information out of the client than the attorney can justify billing to file it, because it's a 2-page form. And secondly, I personally would rather have my clients doing it on their own. It's much less expensive, and doing it frequently and protecting all their work, so when somebody does infringe, it's easy to go after and get them. You've got that registration there. So who owns the copyright? This is a very important issue for small businesses in particular, because people think if I paid you to make it, I own it, and that's wrong. That's just not the law. Ownership is in the creator, not the payer. So if I go and hire as an independent contractor some coder who writes me computer software that I use in my business, guess what? The coder probably owns the copyright. That can be devastating when you go to sell your company, and guess what? You don't own the copyright in the product you're selling. You may have a license, but you don't own the copyright. So it's very, very important. If you are going to have anybody outside your company do work for you, you need to make sure that you get an assignment of rights, all the copyrights, over to you as part of the deal. So when they get their check, you get ownership of the copyrights. That works, but just assuming that because you paid for it, you own it is a key to disaster. And I've counseled businesses before who, they're launching a product and all of a sudden the person who designed it says, oh, I own that, you can't do that. So unless it's an employee, there's a different law called work made for hire doctrine, where if they're an employee, it's usually the employer who owns it. But if you're going to have a contractor, always have a written agreement to assign. A major mistake of small companies is they contract stuff out and they don't get it protected. And even if they don't object to your use of it, right? If you pay, programmer A to go out and write your computer software, the second worst thing that can happen is they go sell it to their competition. Only you paid them $20,000 to write it from the ground up, and they go sell it to your competitor for 10 because, hey, they've already got it. So if you're going to have people use outside code, you want to have good agreements that limit what they can do with it, so they can't go and sell that to your competitor and effectively give your competitor a subsidy to compete with you. Copyright damages. If you find somebody's been infringing a work, number one, you can get actual damages. I mean, damages you can prove. And the damages are kind of interesting in copyright law. Number one, it's what you lost, which is a normal damages calculation. But the second half of that is the infringer's profits. So I can actually go and look at what the infringer made. So let's say you would have made $1,000 licensing that, but the infringer went and took your design and made $50,000. Well, you can go after the profit that the infringer made. The other interesting thing about that is that while you have to show the gross sales that the infringer made, the infringer bears the burden of proof on any expenses in getting to that gross sales number. Now, in a lot of contexts, infringers don't keep really good records. So if somebody infringes your architectural copyright plan and goes and builds a $500,000 house, and you say, okay, well, here's evidence that you were paid $500,000 for that house, they now have the burden of showing whatever their expenses were in building that house. And if they don't keep records, they've got a problem, because you could claim that $300,000 or $400,000 of that house is profit. So it's very important to get your registrations and align your copyright case up well if somebody's infringing. The second thing is statutory damages, I addressed a minute ago. The base range is from $750 to $30,000. It can be reduced to $200 if it's an innocent infringement, and that's a much narrower exception than a lot of people think it is. You hear that every time you assert a copyright against somebody, oh, it was an innocent infringement. But it's a narrow category. Or if it's willful infringement, the judge can increase the amount up to $150,000. So, and I've had several cases where the judge took 3 or 4 times what we thought our actual damages were and awarded those to us because of that. And then your attorney's fees, like I said, this really can change the dynamics of a piece of litigation. One thing that's important for everyone to understand in copyright law is just because it doesn't have a copyright notice on it doesn't mean it's not copyrighted. One that happens all the time, people hop on the internet, hey, I want to use an image, they hop on Google, it does a search, they grab the image, they put it on. That is a huge mistake, because sooner or later somebody will find out that you've done that. Everybody assumes you can't, but there are actually bots that will search the internet and find images. And we actually represent a wildlife photographer who we have close to 100 cases where people have stolen her images and used them on their websites. Because it's a really cool, image of, an eagle taking flight or an osprey catching a halibut or something. And they just use it and assume life's good. And I got it for free off the internet. Well, just because you can't see the copyright notice doesn't mean it's not protected. And in these cases, they actually remove the copyright notice. But there are often people say, well, I didn't see the copyright notice, so it's okay to copy. It's not. That's just a dangerous position to be in. Do not copy works. Find out, go to a site that sells free or that allows you to download for free, or go to a legitimate pay site and pay for the image. Paying $50 or $100 is a whole lot cheaper than getting sued for copyright infringement. Dmca copyright infringement. This is another important issue. Who's the infringer? Well, the person who's posting it is the infringer, but is the website owner liable? Well, potentially, it just depends. So there's several safe harbors. So people who merely transmit data, technically they're copying, but under the Act, they're relieved from liability. Caching services, providers who store users' materials, and search engines that link to materials. So Facebook isn't liable if you go out and copy my work and post it on your Facebook page, because they're just a passive intermediary. They're not actively involved in it. However, they can lose their safe harbor if they're notified and they take no action to take it down. So that's an area of law that's important to pay attention to if you're in the providing online services space, that you make sure that you have a designated copyright agent and whatnot. Another interesting thing with the Dmca is that it provides a very strict penalty for removing copyright management information. It's a minimum statutory fine of $2,500 up to a maximum of $25,000, and if you can show the person's been caught doing it before, the judge can treble that. So it can be very expensive. So if you find an image you like and you think, I'm going to be cutesy and just cut out the copyright notice and use it on my website, not only are you going to be paying the whatever the rate was for that image, but you're going to be paying a $2,500 fee minimum on top of that for removing the copyright notice. So copyrights, they're relatively simple, but they can be really important to a company. Thanks.